The Clarke Inquiry, in a sense, is a virtual inquiry. Mr Clarke has to report by the 30th of September. We, along with a number of other people, have made submissions. Our submissions are now available on the internet, as I said, on Mr Clarke's site. Some submissions are not yet available. We thought by now we would have the submissions of the AFP, but Mr Clarke hasn't posted those even in an amended form. He's sent them back to the AFP to do another submission which he can post on the net, which doesn't have anything in it which might be of national security importance or hinder operations. So we've been in correspondence with Mr Clarke about that, and we're looking forward to seeing the submissions of the Department of Immigration and the AFP, that they're not available yet. The Attorney-General's Department has put a submission in, and then what Mr Clarke intends to do is to interview a number of people. We're not privy yet to who he's going to interview, but our understanding is that after the interviews have been conducted, that those interviews will be posted on the internet, and then presumably we'll be able to make some comment with regard to that. We also thought that documents were going to be posted on the internet from the AFP, all of the relevant documents, again subject to documents which might impact on ongoing operations or national security or pending trials. Mr Clarke hasn't posted any original documents of that kind up yet, so we're just trying to clarify what the situation is with regard to that, and whether we can still expect to receive those documents. Well, what the AFP say by press release from time to time is that Dr Haneef is still being investigated by the AFP. They've never asked to interview him again, and we're not aware of any evidence that they have, additional to what Mr Bugg looked at, which would suggest that Dr Haneef is a proper basis for investigation. But Mr Bugg, who was then the Commonwealth Director of Public Prosecutions, he looked at all of the evidence that the AFP had, and he also took into account any evidence that they were likely to receive from then current investigations, and he took the view that there was no reasonable basis of obtaining a conviction against Dr Haneef at that time. From our point of view, from my looking at all of the documents and all of the questions that have been put to Dr Haneef, there doesn't seem to be any evidence at all that Dr Haneef has committed any offence at any time. But certainly, if the AFP have any other information which would indicate anything else, they've certainly not asked Dr Haneef to be available to be asked questions about that, so we're not really sure what it is they're talking about when they say things like that. But it creates a very difficult situation for Dr Haneef, because if you've been detained for 23 days and then been completely exonerated, and you've got a 1-year-old baby girl, it's pretty hard to say to your mother and to your mother-in-law, look, everything's going to be okay, don't worry about what Mr Kelly's saying about me being investigated. I want to go back to Australia and everything will be fine. So it makes it very difficult for Dr Haneef to make a decision to come back to Australia and continue his studies, which he was enjoying, and his work, which he was enjoying, and live in Australia, which he and his wife were enjoying, when those sorts of statements are being made, albeit without any attempt to ask questions or indicate what the basis of those statements are being made by the most senior police officer in the land, the Commissioner for the Australian Federal Police. So, as far as Dr Haneef's personal life is concerned, those statements make it very difficult for him. Provisions under which he was dealt with are amendments that were made 2004. Now, when I first was involved in the case, I was a little confused because I was aware of the 2005 amendments, which provided for preventive detention orders and have all those onerous provisions such as you can't tell anyone why you're being detained, and the lawyer cannot tell anyone that the person is being detained. They carry a 5-year maximum penalty, I think, those provisions. The amendments in 2004, they actually, things like that have been in the Crimes Act since about 1991, and they provide that a person who is arrested can be detained for the purpose of investigating whether that person, whether the person committed that offence, and with regard to the bits that were put in 2004 with regard to terrorism, they go on to say, or another terrorism offence. So they're actually quite narrow provisions in a way. All you can really hold the person for is to decide whether or not he's committed the offence that you've arrested him for. In the submissions that we've made to the Clarke Inquiry, we suggest that the police were using the detention for a much broader investigation. That is, they seem to want to investigate whether Dr Haneef has committed any possible offence at all, rather than one which he's either been arrested for or they have a reasonable suspicion that he has committed. So it's a very broad process that the police officers have regarded as being permitted, whereas we've argued that it's a much less and much more narrow process. So it seems, according to the submissions, that the police officers have either misunderstood the provisions completely or they've ignored the limitations of those provisions. Well, I'm not aware of any other provision that provides for detention without charge that has been used. Our understanding is that the provision in the Act, which existed in there since 1991 for other offences like murder, for example, serious offences, was never used in the 17 years or 16 years that it was on the statute books. I'm not aware of any other state provisions that provide for that. Certainly the evidence which was given by officers of the Attorney General's Department to the Senate at the time that those 2004 amendments were being contemplated, they suggested that any suggestion that a person might be detained for 2 or 3 days as opposed to maybe 15 or 16 hours were ridiculously high suggestions. And it's my understanding that the provision to apply to a magistrate or some other judicial officer for downtime orders was actually a safeguard to make sure that there was judicial oversight and wasn't intended to allow detention for weeks. Obviously, if that was the intention of the Parliament, it was a mistake not to insert a cap on the amount of time that, if you'd said if you want downtime, you can apply to a judicial officer for it, but no detention can extend beyond 24 hours, then that would have been much safer. But I think the length of time that Dr Haneef was detained was certainly a shock to anybody who'd given evidence to that Senate inquiry and any of the senators who had reported on that inquiry. And I leave it to people who have studied more generally the changes. People like George Williams, I think he talks about the number of amendments that have been made with regard to amendments to Australian law as anti-terrorism measures, and I'm not sure whether it's 64 or 204, but it's an extraordinary change to the legal position, but it's not appropriate for me to discuss those matters because simply I don't have the deep expertise with regard to those matters that people who have studied them much more closely have. I can't recall exactly what the Attorney General, Mr McCelland, said when he set up the inquiry, but it's certainly our understanding that the inquiry will be used by Mr McCelland in terms of his future policy making with regard to the way in which the AFP and ASIO and other security agencies operate, in terms of what action will be taken with regard to Dr Haneef and whether the government will offer him compensation or anything like that. Mr McCelland hasn't given any clear indication in that regard.